Former President Donald Trump is facing potential criminal charges in 2 states, New York and Georgia. While each state has its own process for pardons and commutations, some states lodge those powers with their governor and some with a range of executive officials. In both New York and Georgia, a politically motivated pardon is unlikely. Trump could only apply for a pardon in Georgia after he is indicted and convicted, and only after 5 additional years have passed since completion of his sentence. If a federal indictment is issued, the law around the presidential pardon power is less clear. Trump is currently involved in 3 criminal probes at the federal level. Given the precedent set by President Gerald Ford's pardon of Richard Nixon, there will be considerable pressure on President Joe Biden to pardon Trump should he be indicted and convicted. Ford broke new ground by pardoning Nixon before any charges were brought, ushering in a modern norm of presidential unaccountability. The same logic could hold true for Trump, as a federal trial would likely stretch past the 2024 presidential election, in which Trump is the frontrunner for the Republican nomination. However, the possibility of a presidential self-pardon is highly speculative. Trump may have issued himself a self-pardon while he was president and stored it away in a desk drawer or storage closet for use in rebuffing possible federal charges down the line. No court has yet considered the question of whether presidents can pardon themselves, even for crimes committed in the Oval Office. The Constitution states that the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment, according to law. The U.S. president's pardon power derives from medieval England, originating between 668 and 725 A.D. The English monarch's pardon power was not unlimited. By the time of the American Revolution, the power was shared with the Parliament and the Church of England. The Supreme Court later recognized a number of constraints on the pardon power, including that pardons cannot otherwise offend the Constitution. Presidents cannot encroach on the power of the purse, as only Congress has that power under the Constitution's Appropriations Clause. In Federalist No. 69, Alexander Hamilton justified a broad pardon power for the president by assuaging detractors that the president's power would be much inferior to that of King George III. However, whether Hamilton was correct, or whether modern presidents have in fact become kings, is a question that Trump's record of wrongdoing in office has forced the country to face head-on, once again. Regardless of the legal intricacies surrounding a potential pardon for Trump, many believe that it would be a damaging blow to the rule of law and accountability. Pardons have traditionally been issued in the name of amnesty or to heal the nation after times of crisis. Trump's potential pardon, however, would be measured against the long-standing tradition of presidential pardons and could set a dangerous precedent for future administrations. As the possibility of a federal indictment for Trump looms, the country will have to grapple with the question of whether a sitting president can be held accountable for their actions. The role of the president's pardon power and the limits of that power will also be a critical issue in the coming months and years. Whatever the outcome, the decision will have far-reaching implications for the future of American democracy and the rule of law.